Court is in session.
Thank you, everyone. Please be seated. We have one case on our afternoon docket. It's styled Colorado Oil and Gas Conservation Commission, Colorado Petroleum Association, and American Petroleum Institute versus Martinez et al. We've scheduled the argument for an hour, so we'll give you a half hour per side. We have just a little bit of mix-up in our orders of how we've allowed arguing. So, Mr. Yarger, how are you all planning to split up your time, or are you?
Mr. Chief Justice, I'll be...
Very good. And with regard to the respondents?
Mr. Chief Justice, I will be arguing on behalf of the respondents.
Very good. Thank you very much. Yarger, proceed at will.
Thank you, Chief Justice Coates, and may it please the court, when an administrative agency...
Mr. Yarger, just introduce yourself for the record, please. We didn't ask for appearances.
Of course, Justice Gabriel, I apologize.
I threw you off by calling you by name. Speak for
Fred Yarger, Solicitor General. I'm here representing the Commission. With me at council table is Jake Matter, also representing the Commission, and Jennifer Bevier, representing the interveners. When an administrative agency receives a request for rulemaking from a member of the public, it has broad discretion to decide how to respond. Here, the Commission received a rulemaking petition that asked to drastically change the way the Commission regulates oil and gas operations across the state of Colorado. The petition asked the Commission to halt oil and gas permits across the entire state. It asked the Commission to adopt a zero cumulative impact standard that no human activity could satisfy. It asked the Commission to regulate not just oil and gas operations, but the entire fossil fuel supply chain from operations all the way to end use by the consumer, and it based those requests on the public trust doctrine, which this court and other courts have rejected. In response to this extraordinary request, the Commission went far above and beyond the minimum required of it. It took notice and comment, received advice from its staff, from its lawyers, and from other expert regulators across the state, and at the end of this process, amassed a 1,200-page record. And it was based on this record that the Commission voted unanimously to decline to pursue the rulemaking request. The question here is whether that decision, that order by the Commission, was proper. And there are two aspects to that question before the court. The first is whether the Commission's balanced approach to regulation, the interpretation of the Act that the Commission used to decline to pursue the request, was correct under the Act's language and structure, and the second is whether the 1,200-page record provides other independent reasons to affirm the Commission's order. I'd like to address each of those issues in turn, if I could. The first question is the question of the statutory interpretation of the Act itself. The respondent's position and the position of the Court of Appeals below is that the Commission's balanced regulatory approach is forbidden. What respondents are claiming here is that the Commission has misinterpreted and misapplied the Act for years, which is quite remarkable given that respondents themselves have changed their interpretation of the Act during these rulemaking proceedings. Now, for the first time in this court, they're claiming that there are three separate standards contained within the Act for public health, safety, and welfare, for protection of the environment, and for protection of wildlife resources, when below they argued that there was a single statutory standard that guides the Commission's regulatory activities. But whichever interpretation you take, as the one that respondents are pursuing here, the Act fully supports the Commission's approach to interpreting the Act that it's reflected in its order declining to pursue rulemaking. First, though, it's important to understand how agencies and how courts review these kinds of interpretive questions. They don't interpret the Act in the abstract. They look at the precise question posed by a particular petition and by a rulemaking record. And that's why in cases like Chevron, it's step one, even when you're looking at the text and structure of the statute, you look to whether the legislature has spoken to the precise question at issue. And here, the precise question at issue is whether the commission had the authority to proceed based on the requests contained in the petition, including the request to adopt a zero cumulative impact standard, to look at fossil fuel supply chain issues all the way down to end use by the consumer, and to regulate based on the public trust doctrine.
Counsel, has this court ever formally adopted the Chevron analysis?
I think in a number of cases it has. In cases like Regular Route Common Carriers Association, this court has specifically said that federal decisions construing the federal APA, which is similar to the Colorado APA, are to be used as guides. And the court has also talked about giving deference to agencies when they adopt a formal interpretation if there's ambiguity in the statute. So I think from all of that, yes, the court has adopted many aspects of federal case law concerning administrative law and administrative interpretation.
Do you think we've ever said we have not adopted Chevron?
Not that I know of, Your Honor. And I don't think anybody here disputes, and the Court of Appeals didn't dispute, nor did the district court dispute, that the two-step Chevron approach of starting with the text of the statute, and then if there's an ambiguity, deferring to the agency depending on the formality of the interpretation posed by the agency. Nobody here has suggested that that's the wrong framework or the wrong way to be looking at this case. So here, again, the precise question is, the commission faced with this particular rulemaking request, was it appropriate for the commission to decide that the act doesn't support the specific requests in the proposed rule, in the rulemaking petition, the proposed statement of basis and purpose? And if you look at the actual provisions of the act, and one of the provisions I would point to, and perhaps one of the more important provisions, is 106(2)D, which sets forth the actual regulatory authority of the commission. It says, quote, the commission has the authority to regulate oil and gas operations so as to, and then goes on to discuss adverse impacts on the environment, public health. What that particular provision sets out are a number of factors that the commission must look at in enacting public health, safety, environmental, and wildlife regulations. First is the significance of adverse impacts, not just whether or not an adverse impact will result from a particular activity. Second, whether those impacts can be not just prevented entirely, but also mitigated. Third, whether the measures to prevent or mitigate those impacts are cost effective. And fourth, whether they're technologically feasible. So all of those elements of that particular statutory provision strongly indicate that the commission can't adopt the zero cumulative impact standard that the rulemaking request asked the commission to adopt. And that's one of the central reasons why the commission decided that it couldn't pursue this particular request.
Mr. Yarger, so this, if I'm understanding you, is not a matter of the jurisdiction of the commission. You're talking about authority, I think, in a different way. If I'm hearing you, the question, what you're saying is the commission decided it could not adopt the rule that was proposed here because that would, to do so would be inconsistent with the language of the statute. That's very different than, if I can use it, subject matter jurisdiction. Am I understanding you correctly?
That was one of the central reasons that the commission cited as a reason not to pursue the rulemaking request. There was this additional issue, which is that parts of the request, including the request to look at the entire fossil fuel supply chain, including end use by the consumer, that's more properly the purview of the Department of Public Health and Environment, which looks at statewide emissions issues, groups sources of emission into categories, and then imposes regulations on those entire sectors or groups of emissions. So there was a jurisdictional issue. I think that informs the general statutory interpretation question, but just looking at the petition and aspects of it and the regulatory standard that it was asking the commission to pursue, yes, I think the answer is it's an authority question in the sense of what standards has the General Assembly provided to guide the commission's regulatory authority, and are those matching up with what is requested in the rulemaking petition.
So based on that, I mean, do we need to decide, I mean, the question, the briefs have teed this up as the commission says it's a balancing test between public health and development. The respondents say, no, it's a subject to condition precedent. Do we need to decide that question in this case? I mean, it strikes me, or at least I'm wondering whether the question is much more limited than that.
I think this court can certainly come at it from a much more limited perspective. And if you look at the order of the commission itself, it talked about balancing, but then it said, and this is a quote from page 3 of the order, more specifically, the proposed rule hinges on zero cumulative adverse impacts, and that in particular is outside the scope of the regulatory authority of the commission. And I think that's important because one of the things that I think might have been lost in some of the briefing here is looking at exactly what it is that the commission ordered and decided and exactly what it is the commission was presented with in the rulemaking petition. And if you look at those two issues, as you have to as a review in court looking at the record before the administrative agency, I don't necessarily think you need to decide for all time every interpretive issue that could possibly arise before the commission when it approaches public health and safety. I think you can look at this petition and affirm the commission's order on the basis that it decided in this particular case it couldn't grant what the respondents were requesting. There are other substantive provisions beyond 106(2)D that lend weight to this interpretation of balancing, first of all, and sort of the scope of the rulemaking request. I've noted oil and gas operations are what the focus of the regulatory authority of the commission is. That's a defined term in Section 103 of the Act. It does not include end use by consumers. It involves exploration, production, construction at the well site, and closure. So that again, is a reason to affirm the commission's order. There are other provisions in the Act that make quite clear that there's a state interest in production, protection of correlative rights, prevention of waste. All of those provisions are important to the commission's regulation of the industry. And the other note I think that's important here is in 2007 when the General Assembly really revisited environmental protection in the context of the Act in a broad way, what it could have done at the time is said, during the course of your extensive rulemaking proceeding, you should impose a moratorium, halt new permitting for oil and gas statewide, and proceed to revisit all of your regulations on environment. It didn't do that. And I think it didn't do that on purpose. And that's exactly what respondents requested the commission to do, halt new oil and gas permitting statewide while it reconsidered the entire regulatory framework and how it protects the environment and wildlife resources. You'd think if that was the intent of the General Assembly, it would have been more clear in the Act. It's not, and I think that's a pretty strong indication the General Assembly didn't envision that process playing out in the way that respondents suggest.
Mr. Yarger, looking down the row, I don't see anybody leaning in, so I will. You've used the word balancing a couple of times. Can you talk about how you interpret that phrase? My concern is I'm not sure I can read in the language here balance in terms of, the interest in one is stronger than the other, and it's simple as that, as opposed to considering all the different factors and taking them into consideration. So for clarity, and I would say too, the respondent's argument about how balanced is used in the legislative declaration makes some sense. But I'm not sure we're all on the same page about what balancing means.
Sure, understood. And I think, Your Honor, I agree. Balancing is a complex subject, and that's why it's entrusted to a diverse commission that has various types of expertise and various representation on the commission. So the way the balancing actually plays out when you look at the individual sections of the Act, you start with 106(2)D. There are factors that the commission absolutely must consider: the significance of impacts, cost effectiveness, technical feasibility, prevention, and mitigation. Those are all factors that must be considered. Next, you put that to a commission that, again, is made up of some of the chief environmental regulators in the state of Colorado, the director of the Department of Natural Resources and the director of the Department of Public Health and Environment, others with environmental and soil conservation expertise, and of course members of industry. That's another way that the balance takes place and finds its way into the regulations. I think at the permitting level, you see this taking place on a site-specific basis where there are conditions of approval attached to oil and gas development permits. And a lot of the balance takes place in that context. So depending on the proximity of surface waters, additional measures might be implemented to ensure that leaks and spills don't find their way into surface waters. If groundwater is shallow to the surface, closed-loop drilling systems can be required to ensure, again, that no leaks penetrate into aquifers. There are all kinds of ways that the balance occurs. And then finally, on the back end, ensuring that the balance is done appropriately is part of judicial review. Anytime the commission engages in rulemaking, it has to develop a record. It has to make sure that it explains itself, and its rules have to find support in that record based on the factors we've just been discussing. And then the court uses that record to decide whether the commission acts in a reasoned way. So that's the way that my client, the commission, I think foresees this balancing taking place. It's not an either-or proposition. It's not a zero-sum, and it's not a zero cumulative impact standard. It's complex, and that's why the General Assembly, I think, has reconstituted the commission, required cross-agency collaboration, and has imposed the standards it's imposed. I do think it's important to look at the legislative declaration. That's certainly part of the mix here. But the caution and the arguments that we're emphasizing in our brief is the one thing you can't do with the legislative declaration is use that to contravene substantive provisions in the Act or use it to add substantive requirements that are not found in the substantive provisions of the Act. And this court has said that a number of times, so has the United States Supreme Court. But even putting that aside, if you look just at the legislative declaration, what you see is language like foster the responsible, balanced production of oil and gas resources. Foster, means promote growth and development. I think as we've explained in the briefing, responsible and balanced is a substantive matter. The meaning of those terms is for a responsible person to look at an issue from all sides and consider all various factors, not to consider one or the other or to impose a standard that couldn't be met. So all of those, terms put in context of the Act as a whole, I think indicate exactly what the Commission has adopted over the past 10 years, which is a balanced approach to regulation, meaning taking account of all the factors relevant to making responsible regulatory decisions. And then the final point I'd like to make with respect to sort of the statutory interpretation argument, and this still comes in at step one, is the regulatory history and the administrative history. The Act was last significantly amended to address environmental concerns in 2007. As part of that legislation, the General Assembly specifically directed the Commission, in cooperation with other state agencies, to embark on a very significant rulemaking. It turns out that was one of the most significant rulemakings in the Commission's history. During that process, which was extensive, the Commission very explicitly adopted the interpretation of the Act that the Court is now considering, which is this balanced approach to regulation. The General Assembly reserved the right to revisit those rules and to disapprove of any rules it found were not consistent with the Act. It didn't do so, even though it knew that the balanced approach to regulation is exactly what the Commission had adopted. Now, I think this Court's precedents, I think federal precedents demonstrate that that sort of regulatory history, when you have a very concerted, formal effort by the agency to interpret a statute passed contemporaneously to a rulemaking, indicates that the Commission likely got it correct and has not been misinterpreting the Act so drastically as respondents suggest for the past 10 years. You look at the statute, it says specifically the General Assembly reserves the right to alter or repeal such rules. It didn't, and yet it's revisited the Act, I think, 5 times since 2007, since those changes came into place. So all of those things, 106(2)(d), the other provisions of the Act, the legislative declaration, and the regulatory history all point in one direction, which is the Commission is getting it right, has properly interpreted the Act, and appropriately determined that it could not adopt the zero cumulative impact standard that respondents are urging here. So I'd like to touch briefly before I reserve my time on the other aspects of the Commission's order that serve as an independent basis for affirmance, and emphasize that this is a 1,200-page record. In this type of proceeding, when the Commission is not engaged in rulemaking but has decided whether to embark on rulemaking, this is really the height of agency discretion. Cases like ARC Initiative from the D.C. Circuit talk about the minimum requirements that agencies have to comply with when they consider a rulemaking petition, and really the basic requirement is simply that the Commission explain why it chose to do what it did. Here the Commission did that. It issued a 4-page order based on a 1,200-page record. That order was unanimous, and it was done with information gleaned from public comment and from advice from its staff and its regulators. And what the Commission identified were a number of defects in the order, in the petition for rulemaking, and other reasons to deny the rulemaking petition, including the priorities that the Commission had deemed were appropriate to pursue. So the legal defects, including the public trust doctrine, that was throughout the record in this case, the request for rulemaking, including the memo in support, the proposed rule itself, the proposed statement of basis and purpose, the written testimony by Our Children's Trust, and even the verbal testimony by Petitioner Martinez, all of them were based on the public trust doctrine. And what the Commission recognized is that the public trust doctrine has not been adopted in the state, and given that the petition so heavily relies on that, that is another independent ground for the Commission to decline to pursue the rulemaking. On the priority side, what you have is a director's memo from the Director of Commission, Matt Lepore, that walks through all the significant rulemakings that had taken place since 2007 explain how the commission approaches these issues, which is to look at new science and new legal issues as they arise and apply its expertise to consider whether or not to revisit rulemaking, and then do so. And the regulatory history past that point bears that out. Every single year since this petition was filed, the commission is engaged in significant, extensive rulemaking proceedings. And I think that really points up the reason for agency discretion in this area, which is it's the commission's job to set the regulatory priorities of the commission and decide what should show up on its rulemaking docket. And if it has good reasons for doing so, and if it's diligently pursuing its mission, it is not required to pursue a rulemaking request like the one at issue here.
Can you offer an example of something that would pass muster under the Massachusetts versus EPA deference standard?
Yeah, so I think a good example is the Flyers Rights case. That's a DC Circuit case from 2017, where the reasons that the commission or the agency there gave just directly contradicted other information that the commission had at its disposal. The commission, I think it was the FAA, said, you know, we can't engage in this rulemaking because we have studies that already foreclose the question posed. That wasn't true. And the court said, we don't require much of the agency, but at minimum we require that the reasons given not be contradicted by information that the agency has. And certainly that isn't true here. Every portion of that order that the commission issued in this case, if you look through the record, it's very well supported by information found in the record, whether that's testimony by the director of the Air Quality Control Commission explaining how the state goes about regulating emissions, how a zero cumulative impact standard no human activity could meet, whether that's driving a car or turning on your light, and the commission priorities that the director laid out in his memorandum. So I actually encourage the court to look at those cases from the DC Circuit and contrast what the agencies did there to get themselves into trouble, which is really not take seriously a request for rulemaking, versus what the commission did, which was to very seriously and thoroughly consider this rulemaking petition and only after that point decline to engage in rulemaking.
Why do you suppose there seems to be a difference between the jurisdictional provision under 105 and the regulatory authority scope provision under 106(2)(d)? Because I believe that the memorandum that the AG wrote initially used the term jurisdiction, and that implicates 105, which seems to be broader than 106(2)(d).
Yeah, I think the memorandum was focused on the act as a whole. It cited not just the legislative declaration, it also cited various substantive provisions of the act, and then it also went back to the statement of basis and purpose that the commission adopted back in 2008, which is a fairly lengthy document, walks through legal authority and talks about how the commission arrived at its interpretation of the act. I think jurisdiction and authority and statutory standards, those terms have been used a bit interchangeably, but the bottom line is there was a understanding by the commission based on advice it received from the Attorney General's office that the request being submitted to the commission, the rulemaking petition, was outside the regulatory standards provided by the act, and the commission didn't have authority to pursue it, and specifically with reference to the zero cumulative impact standard. So I think what the AG memo was focused on really was what is the regulatory authority of the commission, what statutory standards have to guide its rulemaking, and is this rulemaking request in line with those statutory standards?
As I understood one of the arguments in your brief, you were saying that we could look at just subsection 106(2)(d), and that we don't need to get to the legislative declaration if that's clear. But as I understand what you're saying now, you think we should read them together.
Well, I think you can read the act as a whole. That's part of the job of the court. That's part of the job of the agency when it's looking at the statute. What we're saying that the court can't do, and I think this is one of the problems with the Court of Appeals decision below, is looking at the legislative declaration in isolation to create standards that you don't find when you then go back to the substantive provisions of the act. And that's really the concern of the commission, is taking the legislative declaration out of context, reading it in a way that conflicts with other provisions of the act that the commission is supposed to look at when it's engaging in regulatory activity.
And you believe that we can read and should read 106(2)(d) in harmony with 102(1)(a), Roman numeral 1?
With that portion of the legislative declaration, I think you can. And I think even just looking just at that provision, the legislative declaration, what you see is, foster the responsible, balanced production of oil and gas resources consistent with protection of public health, environment, and the wildlife resources. So I don't think those two are in conflict. I think they're echoing each other, and I think they're something that the court can harmonize. What the court can't do is what the Court of Appeals did, is look just at the legislative declaration and just as an afterthought, look at some of the provisions in the act itself and decide that the legislative declaration supersedes those provisions. That's pretty clear from the precedent of this court that that's just not the way that you're supposed to read statutes, and it's inconsistent with what the General Assembly says, which is that legislative declarations are for clearing up ambiguities, not for creating separate substantive standards.
Well, with that thought in mind, could 106.2D be a complete answer in and of itself then? And maybe you've already said as much.
I think this court could resolve this case looking solely at that provision. I don't
Without
think
even getting into any deference jurisprudence, because that would be based on a lack of ambiguity.
Yeah, and to be clear, we don't believe there is any ambiguity as to the precise question presented to the commission, which is, here's our rulemaking request. Does the statute, including 106.2D, allow you to pursue this request? What the commission determined was no, it can't, because what's being asked for there directly conflicts with 106.2D, among other provisions of the act.
But I guess one problem is that the commission seemed to read into the legislative declaration as balancing test, which then you get down a road of what does consistent with mean. So perhaps you can address that. I mean, I give you a hypothetical. If I call my travel agent and I say, book me a trip consistent with my schedule and my desire to be near the water, and they book me on a time when I'm not available in the mountains,
right,
that would not be consistent with. And I think that's the concern, where I understood the arguments about 106.2D, but when you get into they're focusing on the legislative declaration, I think they got themselves in trouble.
So a couple points in response to that. If you look at the order and the Attorney General memo, they certainly refer to 102, the legislative declaration, but they don't stop there. And to be clear, the commission doesn't view its duty as ignoring the relevant factors. It has to regulate to protect public health and the environment. It has to regulate to protect wildlife resources. What it can't do is do what this rulemaking request asked of it, which was to pursue a zero cumulative impact standard, halt oil and gas production statewide while that standard was being implemented, and consider impacts all the way downstream from the wellhead. So I understand the tension, but I think that it's just reading too much into the legislative declaration, whereas I think what the commission and the AG memo was trying to do was look at that in context of the rest of the act. If I could reserve the remainder of my time.
Please.
Thank you.
Counsel?
Good afternoon. Thank you, Mr. Chief Justice Coates. May it please the court, I'm Julia Olson. I'm counsel for the youth respondents in this case, and with me at counsel's table is Dan Leftwich and Nate Bellinger and Kate Merlin. And also with me today are the youth respondents Shateska, Itzquatli, Emma, and Ariel. Your Honors, this issue before you is a straightforward matter of statutory construction, and I'd like to bring the court back to the question that was presented and that the court asked us to brief and review today. And that is, did the Court of Appeals err in determining that the commission misinterpreted section 102(1)(a)(1) as requiring a balance between, on the one hand, public health, safety, and welfare, and on the other, oil and gas development? And that's the salient question before the court today. So I'd like to also put that question in context. In 2013, the youth respondents petitioned the commission to initiate a rulemaking. And what they asked for was a reasonable rule. They did not ask for a ban on oil and gas drilling, as counsel represented.
Well, excuse me, I'm sorry to interrupt. They did ask for a particular rule, right? Not any reasonable rule, but the rule they requested.
That's correct, Your Honor. They did ask for a particular rule that would require that prior to authorizing oil and gas drilling permits, that the commission show that the best available science would indicate that public health would be protected and not harmed, and that there wouldn't be cumulative impairment to the environment of Colorado. So they asked for a best available science inquiry into harm to public health, safety, and welfare, and the environment prior to issuing oil and gas drilling permits. That was the intent of the proposed rule, and as Jake Matter wrote in the letter to the commission on behalf of the Attorney General's office, because petitioners propose a particular rule does not mean that that specific rule in all of its elements will be granted. And the reason—
Fair enough, but shouldn't the commission take the proposed rule at face value and the request made?
Yes, Your Honor, and I believe that the request to have the commission evaluate the impacts and harms to public health prior to issuing oil and gas permits and ensuring that there wouldn't be adverse harm to human health was a reasonable request that the youth made in their proposed rule. And the problem was, and what the Court of Appeals addressed, is that the commission then interpreted Section 102, 1A1 as precluding them from adopting a rule that would do that. And that interpretation that was not consistent with the plain meaning of the statute then guided the rest of the decision that they made in their order.
I'm sorry, go ahead, Ms. Olson. Finish your remark.
That just colored the rest of their decision.
So I guess I had a couple of questions about what you just said, and I suppose the first is whether you agree with Mr. Yarger's point about the standard of review. This is a request to engage in rulemaking. And Mr. Yarger says, and I think case law does support, that it's the most deferential standard, whether they engage in rulemaking. So first, do you agree with that?
I agree that there is deference to the commission to make findings about whether a rulemaking should proceed, but there's no deference to the commission in terms of its interpretation of the plain meaning of the statute.
Or at least if they get it wrong, that would be abuse of discretion.
That's correct. And I think that preliminary issue, that threshold legal analysis that the commission did, really creates problems not just for this rulemaking petition, but for the actions of the commission going forward. And that it is saying that it can balance public health with oil and gas development.
Well, look at, if I can, the language they precisely used. They talked about the rule presented here would, what they say, cause them to readjust the balance crafted by the General Assembly, et cetera. And the language Mr. Yarger quoted, more specifically, the rule hinges on conditioning new oil and gas drilling on a finding of no cumulative adverse impact, et cetera. Why couldn't the commission reasonably decide that to adopt this rule would be inconsistent with their statutory requirements, among others, of minimizing significant adverse impacts as opposed to no impacts? Why is that not reasonable?
So I'd like to discuss the distinction between significant adverse impacts to the environment versus human health. And I think we need to look at the statutory language for that. So I'd like to take the court back to first Section 106.11a2. So Section 106.11a2 is the substantive authority and the mandate to the commission to promulgate rules to protect the health, safety, and welfare of the general public in the conduct of oil and gas operations. And as your honors can see from that provision, there's no mention of balancing in that substantive provision. And then if you look at 106.2d, that's additional authority and a mandate to the commission to regulate so as to prevent and mitigate significant adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations to the extent necessary to protect public health, safety, and welfare. So again, the significant adverse environmental impacts is not about significant adverse impacts to human health. It's about environmental conditions that harm human health and harm the public. So that's what that authority really relates to.
Now, the commission takes a position here that that's different than the position you took below, where it was a definition of public health and environment. I'm paraphrasing. Public health and environmental impacts, you defined them together, and now you want to say they're different. I guess first question, is that true? And the second question is, how would that make sense that we have different standards depending on whether it's an environmental impact or this impact or public health impact? I mean, it does seem like we would construe words to mean different things in different subsections.
So to answer your question first, Your Honor, no, we did not take inconsistent positions. Our focus in distinguishing protecting public health, safety, and welfare has mostly been made with respect to wildlife because that's where the statute is clearest in the distinction. However, if you look to the rules that the Commission has promulgated, even they have separate rules for health, safety, and welfare of the people. They have separate rules to protect wildlife, and they have separate rules to protect the environment. So even the Commission acknowledges that the General Assembly has framed this statute in a way to treat those three things differently. And if I could, I'd like to turn to the wildlife provisions because I think they're really a good example of this. So with respect to wildlife, if the court would look to section 102, 1A4, again, there, the General Assembly says that the Commission should plan and manage oil and gas operations in a manner that balances development with wildlife conservation. So that's the legislative declaration, to balance wildlife protection with oil and gas development. So when the General Assembly intends to create a balancing test between two interests, it knows how to do so. That language does not exist in section 102, 1A1, which reflects the Commission's obligation to protect public health, safety, and welfare. And related to the wildlife protection requirement in section, excuse me while I find it, 128.3D is then the substantive authority and mandate to promulgate rules to achieve the purposes of balancing wildlife conservation with oil and gas development. And I want to emphasize this point because what the Commission is doing is really conflating the protection that's required of wildlife with the protection that's required for human health, safety, and welfare.
Can I interrupt you there? So in the in 102A1, 1A1, this is the controversial phrase, in a manner consistent with. That ends with including protection of the environment and wildlife resources. So it may be that they intentionally used balance in one place and not in another. It may also be that amendments added one year were added by people who used language like in a manner consistent with when we're talking about the legislative declaration, but that there wasn't careful thought in the legislative declaration to how to express that all of these things are important. Is that not the case?
Your Honor, I disagree with that. I think the legislature was very intentional in when it references protecting public health, safety, and welfare. It did so without any caveat, without any limitation on the Commission's ability to protect public health, safety, and welfare. And indeed, the Commission during the Court of Appeals oral argument actually conceded as much. So in response to Judge Vogt asking a question of the Commission admitted that it could in fact impose a moratorium on oil and gas development if there was unequivocal evidence that the development was harming public health and the environment. So it has conceded that, and that's at Appendix H of our brief, page 17 of the transcript.
Is that inconsistent with the position they take today? I mean, if the evidence showed there was no way to do this in a manner that would preserve public health, that would seem like there's no way to minimize a significant adverse impact. I'm not sure that what they conceded below and what they're arguing now are inconsistent, but you may have a different view. Have at it.
So I think that the Commission, both as they argued in the Court of Appeals and as counsel argued today, and in fact in some of their own rules and their internal guidance, they admit they do have the authority to protect public health, safety, and welfare, even if it means initiating rulemaking for a moratorium, because they do have that authority. But what is at issue here, and the outstanding question I think that's really critical that this court address, is under the plain reading of the statute, does the commission have the discretion under their balancing theory to continue authorizing oil and gas drilling when there is evidence that is harming public health, safety, and welfare? So on the one hand, they say, yes, we have the authority to protect public health. But on the other, they say we have the discretion to allow oil and gas drilling that harms public health. And that's the balancing question that is before the court today. And we agree they have that balancing discretion when it comes to wildlife. But the General Assembly has nowhere in the statute given them the discretion to balance public health, safety, and welfare with oil and gas development.
Let me ask you about that. I think you've distinguished now between public health on the one hand and environment and wildlife on the other. And as I look at subsection 1021A, Roman numeral 1, it refers to the protection of the environment and wildlife resources as being included within the protection of public health. So how do you justify having two different standards when it seems to be a subset of public health?
Your Honor, there's, I think, a simple answer to that. So environmental protection and wildlife protection are sometimes important to protect public health, safety, and welfare. For example, wildlife can be an important source of food for human health. And the environment, whether our water quality is safe or our air quality is safe, can be an important issue for human health. But human health can be directly impacted from oil and gas operations. For example, there have been explosions that have caused death. There are children next to schools who are ingesting and breathing in the chemicals and the air pollution from these operations because they're sited so close to facilities. And so public health, again, I think is separate, and I think the court has to treat human health, safety, and welfare as separate from wildlife or environmental protection when looking at the statute. And I would argue that it's also consistent with the Colorado Constitution, Article 2, Section 3, to read the statute as unequivocally protecting human health, and that there isn't any discretion for the commission to balance human health on the one hand and oil and gas drilling on the other. And to the extent they can coexist together, then the commission can authorize it. But that is really the central statutory interpretation question that the court posed to the parties and that needs to be resolved. And the decision of the commission to deny the petition was based on that improper interpretation of its authority. And while on remand, it might decide that there are reasons still to not initiate a rulemaking based on the petition, it should be required to review the rulemaking petition in light of its correct statutory interpretation and construction.
I want to be sure that I'm understanding your position. So your position is there's no balancing here, that the only way that the commission could authorize drilling is if they can show that there is no impact on public health?
Your Honor, yes, I believe that the statute's clear that the oil and gas development in the state cannot harm public health, safety, or welfare. And the General Assembly has been clear about that since at least 1985, again in its amendments in 1994, and then most recently in 2007. But 1985 was the time when it put in place 106.11A2, which is the mandate, the unequivocal mandate to protect public health, safety, and welfare.
So let me ask you, let's assume for argument's sake that we were to disagree with part of your argument and say we have to look at 106, is it 2D? If we look at that, would that be inconsistent with the argument you just made? Because you said no impact. If there's any impact, they can't approve a permit. Is that inconsistent with saying the commission is to look at mitigate significant adverse impacts?
Your Honor, I'd like to clarify what I said, which is we're not saying no impact. We're saying no adverse impact to human health or no harm to human health. So it's
And
not,
I understood, I was paraphrasing. So let's assume that we think 106(2)(d) applies. Wouldn't that be inconsistent with the standard you're proposing? And I guess the follow-on question is, wouldn't the commission have been reasonable to think that?
no, Your Honor, I think 106(2)(d) is entirely consistent with our reading of the statute. I think it's consistent with our reading of 102(1)(a as well as 106(11)(a)(2), and contrasting those with 102(1)(a)(4) about
But help
wetland.
me understand that then. I mean, it strikes me at least, and I may be dead wrong, as a distinction between no adverse impact on public health and a duty to mitigate significant adverse impacts. And there's language in the statute about unavoidable impacts. The suggestion when you read the statute as a whole is that there's an understanding there's going to be some impact, and it is the commission's duty to decide whether that impact is something that we accept given all the other priorities of the statute. So maybe you disagree that there's a distinction between that.
Your Honor, I think there's an important distinction. So looking at 106(2)(d), it says to prevent and mitigate significant adverse environmental impacts.
Right, and I was assuming that we would not agree, for purpose of the question, that we would think that also applies to public health, just for purposes of my question. If that applies to public health, do we have an inconsistency with your position?
That clause, in my view, does not apply to public health. I think if it read prevent and mitigate significant adverse impacts to public health, then there would be an inconsistency in the statute.
And I understand, but I want you to assume, for purpose of the question, that we would read it as applying to public health based on the language we talked about before in 102, where public health and environmental are all kind of subsumed together. So just assume for my question that we would view this duty to mitigate adverse effects, et cetera, as applying to public health, viewing the statute as a whole.
If the statute said prevent and mitigate significant adverse impacts to public health, then I do think, so Your Honor, let me make sure I'm understanding your question.
Of course.
Would then the commission's are you asking me if the commission's interpretation would then be correct?
My question is, would that be inconsistent with the position you're taking, which is that the commission cannot approve a permit if there is an adverse impact?
I think it would depend upon how the commission defined a significant adverse impact to human health and what that looked like. Because I think there are harms to human health that are not allowed under the statute, which might not rise to the level of a significant adverse impact. For example, such as if children are having an increased incidence of asthma, is that a significant adverse impact to their health as the commission would define it? And I'm not sure whether they would define it that way.
Fair enough. Thank you.
Let me follow up on Justice Gabriel's question. But hypothetically, let's assume there is an oil and gas operation, and let's assume that it has an adverse impact on the environment, but it's not significant. And so let's assume then that the commission decides we don't have to regulate it under section 106(2)(d). You would agree that they're in compliance with that subsection, right?
They would be in compliance with that subsection as long as public health, safety, and welfare were also being protected.
Well, it says that it has to be significant. And in my hypothetical, it's not significant, correct?
Correct.
All right, so let's assume that they conclude this particular operation is not significant, so we're not going to regulate it. Would that be consistent in your view with 102(1)(a)(1)?
Your Honor, I would need more in your hypothetical. I would need to understand if public health, safety, and welfare were also being protected. Because again, I think there can be aspects of oil and gas operation that might not be deemed a significant adverse environmental impact, but may still pose dangers to people. And so I think there's a second part of the analysis that still needs to be done to determine whether the operation is being conducted in a manner consistent with protecting public health and safety. I'd like to also briefly turn to this court's decisions in Fort Collins and Longmont, because I think they're also relevant here. In Fort Collins, this court recognized that the state has an interest in the efficient and responsible development of oil and gas resources, and a strong interest in the uniform regulation of fracking statewide. And the court, as your honors know, revoked the ban and the 5-year moratoria in the two cities as materially impeding the state's interest in the uniform regulation of the oil and gas operations. And writing for this court, Justice Gabriel, your honor did not say that one of the reasons for operational preemption was that the commission had an obligation or the ability to balance the public health and safety concerns that were raised by those two cases. Instead, it was really about the efficiency of operations, protecting against waste, protecting the correlative rights of operators. And I think implicit in this court's opinions is that the commission also does have a mandate statewide to protect public health, safety, and welfare. And the statute can be read consistently in those respects. I think efficiency, preventing waste, protecting correlative rights, all can be done while also protecting public health, safety, and welfare. And the significance of Fort Collins and Longmont is that it places on the commission a very important obligation at this point. They are now the single entity in the state of Colorado, really overseeing the entire statewide operations and the impacts of those operations on public health, safety, and welfare. And I think what happened in Longmont and Fort Collins with the bans and the moratoria, and what we see on the front page of the Denver Post with Proposition 112 being an issue, is that these issues of public health are real. The amici briefs in this case really indicate that. The Coalition of Nurses and the Physicians for Responsibility and others indicate how significant fracking is in terms of its impact on public health, safety, and welfare. And so it's important that the statute be interpreted correctly so that the commission, when they go back to reviewing oil and gas drilling permits, they're operating under the proper construction of their statutory authority. I'd also like to point the court to its decision in Drosty, where the court, in interpreting a similar phrase in a manner consistent with, used the same analysis that the Court of Appeals used below, which is to equate in a manner consistent with subject to. It's a condition precedent to an activity occurring.
Was that reference, though, in that case really part of the holding? I mean, it seemed to me to be part of an introduction to a quotation of the provisions of that statute, and nothing, and not more. So help me understand why that's a holding of sorts.
I think it was an important interpretation of the Land Use Enabling Act. It wasn't the key holding in the case, but it certainly set up the analysis of the local government's ability to exercise broad authority in that case. So while it wasn't the key holding, I think it's instructive to the court here in terms of how it interprets in a manner consistent with. And
Counsel, over here, I'm sorry. I don't want to interrupt your big finish, which you're probably leading to.
Go ahead.
But I did have a question. Mr. Yarger referred to some of the other grounds that the commission at least cited. Had the commission only said here, we decline to engage in rulemaking because other agencies are already looking at these same issues, and so we defer to them, would that have been appropriate?
No, Your Honor, because the commission has independent authority that the General Assembly has given it and a mandate to promulgate rules to protect public health, safety, and welfare. So
does the commission have to engage in rulemaking anytime it comes within its jurisdiction? I'm using jurisdiction now as jurisdiction.
Yes, as long as there is an issue related to public health, safety, and welfare that is not being addressed under its current rules, I think it has an obligation to address that to meet the mandate of its statute.
But why couldn't they say it is being addressed under our rules just by in this different context? So we're going to decline rulemaking for now. And maybe I'm not understanding what's unreasonable about that.
Your Honor, are you saying if the Department of Public Health and the Environment had already promulgated a rule that was addressing,
or they're considering it? They're engaged, there's other entities are engaged in rulemaking, they're exploring it, they're having hearings. So at this point, we're not going to engage in rulemaking. We're going to let those other folks do their work. And that seems to me sort of what they said in their order, but you may read it differently. Why is that unreasonable?
I think if there were an existing rule on the books that met the purposes of the Commission's mandate, that they could defer to that rule potentially. But if another agency is in the process of considering rules, I don't think they have the ability to defer considering a rule that would protect public health and safety that's not currently being met, unless they worked with another agency to do so. And I think Massachusetts versus EPA is instructive on that. The agencies have concurrent jurisdiction, and as in certain rules related to the corporate average fuel economy standard, EPA and the Department of Transportation will work together on those rules.
You're taking another deep breath. You're ready for the final onslaught. But I just want to ask you about 106.2D again before you do that. And I want to make sure I'm understanding your argument correctly. So as I understand it, you're saying it's the combination of maybe 106.11A2 and the use of the word environmental to modify impacts that means it's not relevant to public health, even though it goes on to say to the extent necessary to protect public health, et cetera?
Oh, Your Honor, I think adverse environmental impacts are very relevant to public health, but there's not a standard in the statute that says that the Commission can allow for any kind of balancing related to public health. So
No, but specifically 106.2D, you're saying doesn't apply to public health for the reasons that I just stated. In the brief, you talk about the word environmental qualifying impacts and not ultimately the public health piece. Is that right? Or impacts to the environment. Well, you articulate it. So help me understand why 106.2D doesn't apply to public health, even though it goes on to say to the extent necessary to protect public health, safety, and welfare.
it does apply to public health, but the clause that says that the Commission should regulate to prevent and mitigate significant adverse environmental impacts.
Does not because?
That's an important thing for the Commission to do so that it's protecting public health. But it's not mitigating significant adverse impacts to public health. It's mitigating significant adverse impacts to the environment.
I see.
So where in the statute itself then, not in the legislative declaration, but in the statute itself, do you find the provision that says the Commission can only act to have new oil drilling if it finds that there is no adverse impact to human health?
So there's not a provision that says that in the statute specifically. The provisions we rely on are 102.1A, I'm sorry, I have my provisions wrong, 102.1A1 and 106.11A2. Specifically,
which refers to protecting public health, right? It says that working with the Department of Public Health, the Oil and Gas Commission can protect public health, but it doesn't say, and it doesn't say what standard that is, that it's avoiding any impact on public health. I used up your time, I'm sorry.
Well, again, Your Honor, I think that's where 102.1A1 comes in. So just as 102.1A4 informs how they protect wildlife, 102.1A1 says that the fostering a balanced development and responsible development of oil and gas resources can only be done in a manner consistent with protection. And 102.1B is consistent with that analysis as well. And I see that I'm out of time.
Thank you.
Thank you.
Appreciate the argument. Like the petitioners still have some time.
Thank you, and I just have a couple of points, I think, in rebuttal. First is this distinction between 106.11 and 106.2D. 106.11 does, Justice Hart, talk about protecting public health and safety. When the legislature uses that term protect, I think there are two things to keep in mind. One, you can't read that in isolation from 106.2D, which talks about significance, talks about technical feasibility and other factors. But even if you just look at section 106.11, the term protect, I think, is used in other statutory schemes about environmental protection, and I haven't heard of a court reading that phrase or that term in isolation to impose the sort of zero adverse effects or zero harm standard that respondents are urging. If you look at, for example, the Clean Air Act that uses that term, protect air resources, no agency, no administration of the EPA has suggested that that means that power plants across the country must be shut down and not allowed to operate until a zero impact standard is met. Same with the Water Quality Control Act of the state of Colorado. Again, the term protect water quality of the state does not mean industrial activity can occur. And I think one helpful place to understand this and put this in context and really put this back in the perspective of the commission as it was considering this rulemaking petition, if you look at the administrative record at page 1103, you'll see testimony from the director of the Air Pollution Control Division. And what the director talks about is that, and I'd like to, if I could, read some quotes. It's important to know just about every activity that we engage in modern life does have some impact on our air quality. That includes driving cars, with both, which of course has public safety impacts, accidents on the roadway, but not just that, greenhouse gas emissions, air toxic emissions that can lead to public health events as respondents were describing. Electricity production obviously has significant effects, home heating. And what Director Kaufman concludes is oil and gas, the industry, in this regard is not unique and shouldn't be treated as such. And I think that's the approach that the commission takes when it reads the statute as a whole, as it's supposed to do. Its job is to regulate the oil and gas industry, taking into account all relevant factors, including the public health, environmental, and wildlife impacts we've been discussing today, but not to do so in a way that imposes a standard that the industry, no matter how carefully regulated, could meet. And the other aspect of the question that I would sort of emphasize here is what respondents are saying is that the commission, I think she said it again during argument, has been misapplying its mandate since 1985, which is quite remarkable to assume that the General Assembly, aware of the commission's actions over that time, the commission has been subject to significant oversight, has never once suggested that the commission should either order a moratorium on new oil and gas permits or change the standard under which it regulates.
So, Counsel, I'm sorry, you're about to run out of time, and I have just one quick question for you, and that is to throw the question that she posed. Does the commission have the authority to authorize drilling where there is information that such drilling does harm public health? And how do we tie that to protecting public health?
And that's why I pointed the court to that citation 1103 of the administrative record. What the commission can't do, it has to consider these public health impacts. In fact, right now the commission is revisiting its setback requirements for precisely that reason, because it wants to revisit the literature and the technical and other aspects of the problem to ensure that its requirements are at the forefront of the industry. And to be clear, the commission has always been at the forefront in the last 10 years. It's been a model for other states, and it's been a model of federal government. So what it can't do, Justice Marquez, is adopt the no harm or zero adverse impact standard that respondents are urging on the court. What it must do is consider public health safety, consider environment, and consider wildlife, and ensure that its regulations, considering those factors and the best available science, protect public health safety and the environment. And if there are no further questions, thank you.
Thank you. We appreciate the arguments of both counsel. Case is going to stand submitted. Court will be in recess until 9 o'clock tomorrow morning.